Good afternoon, everyone. Thank you all for joining this session. Today's webinar is about plea bargaining in Kenya. We have our moderator on call. We have our judge on call and a representative from the ODPP. Kindly allow me to hand over the program to Mudhoni, our council member, to take over and introduce the panelists.
Thank you, Wendy. Good afternoon, members. Thank you so much for joining us this afternoon. My name is Mudhoni Gashara. I am a council member, Nairobi branch, as well as the organizing secretary. Today, as Wendy has said, we are having a webinar on criminal law, and our topic is plea bargaining in Kenya, enhancing justice, efficiency while safeguarding rights. We are privileged to have Justice Muteti with us this afternoon, as well as our colleague from the ODPP, Ms. Becky. Thank you very much for honoring our invite and having you and just being with us this afternoon. We look forward to a very engaging discussion, one that involves learning. So Justice Muteti is a judge of the High Court, currently stationed at Milimani Criminal Division. He is a seasoned legal professional with over 2 decades of experience in public prosecution, having worked at the Office of the Director of Public Prosecution and Office of the Attorney General. Prior to his appointment to the High Court, he served in various senior roles at the Office of the ODPP, most recently as the Senior Assistant Director of Public Prosecutions from the year 2016 to 2024. Justice Muteti holds a Bachelor's of Law from the University of Moi University, postgraduate diploma in law from Kenya School of Law, and a Master's of Arts in Public Policy and Administration from the Kenyatta University. Judge, we are happy to have you. And also with us, we have Ms. Becky Arunga. She's an advocate of the High Court of Kenya. She holds a Bachelor's of Law from the University of Nairobi, a postgraduate diploma from Kenya School of Law, and a Master's of Law from the University of Nairobi. She is currently a prosecution counsel at the ODPP, where she heads the cybercrime section, and she's also a member of the Kenya Cybersecurity and Forensic Association. We welcome you to our session today, Becky. So we are going to start with the judge, and then we will have Becky do their presentations, and thereafter we will have the Q&A. Welcome very much, Judge.
Thank you, Mudhoni. Good afternoon, everyone. Allow me to begin by first thanking the Nairobi Law Society branch for inviting me to speak to you on this important subject of plea bargaining today. This is a subject that is close to my heart because from what I have gone through previously as a prosecutor and my experience in the criminal courtroom has taught me that much needs to be done so that Kenya can begin rating itself or ranking itself with the rest of civilized world in terms of expeditious disposal of criminal cases. By way of introduction, the plea bargaining chapter in our criminal procedure code was introduced immediately after Act number 5 of 2003. This is the act that did away with the committal bundles as we knew them, or committal proceedings in the lower court, which was a procedure that basically all murder suspects would at first be arraigned before a magistrate, and then it would take ages before a bundle was prepared for onward transmission to the magistrate, and then later to the High Court after the Attorney General had given consent to charge with the offense of murder. Of course, that presented serious challenges, and there was need to do away with that procedure. And come the year 2003, with the NAC government coming into office, the government immediately did away with that procedure, and through Act number 5 of 2003, all matters moved to the High Court. But then we immediately realized, for instance, in the court station that I served that time, that was Meru, we had a jump from about 60 cases that year to about 183 in 2003, all murder cases that were registered in the High Court courtesy of that transition. Obviously, it became clear that it was not possible to resolve all these murder cases using the traditional methods of hearing a criminal case right from plea to conclusion. And therefore, there was need to come up with a legislation. And I was again privileged to be part of the team that worked on this part of the bill. That was a committee of the law reform of the ODPP, which worked on a bill that eventually led to the enactment of Part 137A to 137 of the Criminal Procedure Code, which is now the law that we utilize in plea bargaining. Now, one may ask, then, what is plea bargaining? And the quick answer to that is that it's a formal agreement it's a formal procedure, really, that involves an agreement between an accused person and the prosecutor to try and resolve a criminal matter. And this agreement could take several forms. This agreement could involve a reduction of a charge to a lesser serious offense, withdrawal of some counts or some charges that may have been preferred, or even involve the recommendation of specific sentences to a court once a plea of guilty has been entered against an accused person and a conviction rendered. Now, let me emphasize on something here. Most of the plea agreements that are done presently, I think very little has gone into the area of making recommendations to courts on the sentences to impose. The court hearing a plea agreement issue really retains the sole discretion in sentencing, but it is important for counsel, for both the prosecution and the defense, to make proposals to a court as to what they consider reasonable and proportionate sentence in respect of a particular offense. That, of course, helps the court in trying to weigh the conflicting positions taken by victims at times, and also the demand for action against the persons who are accused of crimes before our courts. So it is important for you as counsel to remember, even as you conclude a plea agreement, always have an aspect on sentence recommendation to the court. You may also, in that plea agreement, agree to compensation and restitution of these victims involved. Now, this is yet another forgotten area. Let me take, for example, the cases of murder that come before us every day. You rarely hear anybody talk about any settlement that has been reached between families of victims and the accused person's families. Yet, this could be actually the thing that will unlock the question of sentencing, in the sense that where victims have been reparated by the persons accused of killing their kin, they would relax their positions more often than not in terms of the sentence or severity of sentence that they think should go against an accused person. So it is important, and to broker peace between families, because most of the murder cases, again, you will find families are involved. It could be as a result of a domestic violence issue, which then means there are children who have been left out there and they have no one to take care of them because the father is in custody, the mother is deceased, or vice versa. Because again, we are also seeing instances where the men fall victim of these assaults that eventually lead to murder. So that then for you as counsel, appearing for these accused persons, you need to balance those issues, look at the welfare of the children, talk to your client, as well as the prosecutor who reaches out to the victims, to see how you can narrow the gap and agree as to issues of compensation and appropriate sentences that may be rendered. Now, what is the scope of plea bargaining? Of course, this would go for almost every other offense except a few that are specifically mentioned in the plea bargaining chapter of the CPC. And those ones include sexual offenses where you cannot apply plea bargaining, genocide, crimes against humanity, and crime and war crimes. Obviously, these offenses were singled out because of their gravity, and also taking into account the fact that they involve or they actually come with a lot of traumatic experience on the part of victims. For instance, sexual offenses, if we were to allow negotiations or plea bargaining into some of those cases, the child or victims would be greatly exposed. Our women, of course, who are also vulnerable, would be exposed. And then for the greater interest of society, we felt and Parliament agreed that it was not necessary to allow plea bargaining in respect of those, so that we leave those cases to the traditional dispute resolution mechanisms through application of criminal law in the strict sense. The process, how do you initiate it? It could be started by the accused person through his defense counsel, or this could also be begun by the prosecutor. So it should never surprise you as a defense counsel when the prosecutor approaches you and says, look here, we are looking into this matter and we think that a plea bargain would be more suitable for your client. I would encourage a situation where both sides of the bar really initiate these plea bargains. Because at times, as a defense counsel, you may look at a file, look at the evidence that is against your client, but then you can obviously identify some serious weaknesses on the prosecution's case that may not be too obvious to the prosecutor, and that if the prosecutor were to take them into account, probably they would have arrived at a different decision. So raise these issues, have discussions between yourselves, and then see how you can apply plea bargaining to minimize the number of cases that keep coming to court. Victims also could initiate these matters of plea. Take, for example, a family that has lost a relative, and that family has been adequately compensated. Of course, there can never be compensation that would replace human life, but victims have reached an understanding with the family of the accused person, and taking into account all the circumstances surrounding the commission of an offense, they have the view that this person should not really be kept in custody or should not be kept in custody for long. Those victims could as well initiate a plea bargain. That becomes particularly important when you look at some of our traditional practices and customs. Say, for instance, the masla practice in the northern Kenya, some traditional mechanisms applied by the Njuri Njeke of the Meru community, the clan system of the Kambas that also embraces some good degree of plea bargain. And I'm sure in almost every other African community, there was a way that traditionally they would resolve some of these matters. That makes the case for alternative justice systems under Article 159(2)(d), because alternative justice system cannot be ignored today. It will not fall within the realm of a plea bargain, but then once you have resolved the matter through application of those traditional mechanisms, then it doesn't harm for you to come to the criminal court and say, look here, judge, as you seek to try my man, and as the prosecutor comes before you prosecuting my client, it is important that this court also takes note that through other mechanisms, we have been able to resolve this. That is going to help us in reducing the number of cases that we have to deal with on a daily basis. The court will not be involved in your plea negotiations, but obviously once you file the plea agreement, the court is expected then to look at that plea agreement and grant its approval. There will be instances where, for instance, you will come up with a plea agreement, but the court will reject it. It should never surprise you when a judge listens to a matter and feels that this matter really does not merit plea bargain. That could be for many reasons. Well, number one, it could be a case of a complete misunderstanding on the part of the prosecutor in interpreting the facts that are before them. And clearly, in some instances, you come across cases that are purely murder, but they have been reduced to manslaughter. In such cases, a court may withhold its approval of the plea bargain. But then the most important thing is that where a court rejects your plea agreement, then that court should not proceed to try the accused person. Obviously, as a judge, I will have heard the facts that you have read out and having formed the opinion that indeed you were wrong as counsel, or you did not consider certain aspects of the case, which as a judge I feel militate against a plea bargain, that I should not proceed and hear the matter. So the order that should follow such a rejection is a transfer of that matter to a different judge for hearing and resolution. Now, when we come to sentencing, as a judge, I'm required to take into account your proposals on sentencing, but obviously, again, I will also have to look at the time taken before that plea has been made. Let us avoid, as counsel, waiting until the very last witness has testified, and then you realize, actually, we have no defense. So let us try and negotiate with the prosecution and see whether we can enter a plea bargain. You will have already prejudiced your client because much of the evidence has already gone on record. And two, you've wasted a lot of court's time, which may have been saved if a plea agreement had been entered into in good time. One may ask, are there safeguards so that you do not compromise justice in the course of plea bargaining? Yes, indeed, under the framework 137A2O, these plea agreements must be voluntary and the accused person must participate throughout the process voluntarily. And if for whatever reason it comes out or it gets known to the court that there was some aspect of either coercion or intimidation into a plea agreement, that would vitiate a plea. So voluntariness of the process is important, and the respect for the rights of the accused person throughout that process is also key. I would emphasize that when you negotiate a plea agreement, it's important to point out to the accused person that this agreement, though we are going into it, there are no guarantees on certain things, such as the sentence that you may end up with. But of course, let them know that you will make your proposals, but the judge retains the last word on sentencing. Why is that important? Because these people need to understand the array of sentences that are available and what are the risks of waiting until a court tries you for murder only to convict you for manslaughter after 5 years, and you have been sitting in custody. Probably then you are convicted or found guilty for manslaughter and given a sentence of 3 years, something that you could probably have served and gone out of prison long before. So as you deal with these matters, look at the practicalities of having some of these plea negotiations early enough and in good time to avoid subjecting an accused person to an unnecessary stay in custody. Now, what are some of the challenges that we encounter in dealing with plea bargaining in Kenya? Number one is lack of public awareness and trust. Of course, this issue of trust is something we have to keep building on because, again, our society has not fully embraced this concept. In fact, in certain quarters, it is viewed as allowing prosecutors and accused persons to cut deals to avoid trial and also to evade justice. But that is not the position. We need, as advocates, to assist the courts and also assist the public to get to understand that this process is a lawful process, is legally recognized, and is helpful to us as a society. I talked about coercion and voluntariness, that I will not repeat. Now, judicial discretion in sentencing, again, that I said is very key, but that will be informed by the circumstances of the case. And in every case, as a defense attorney, please try as much as you can, if there are some mitigating factors in your case that you think in the preparation of the facts have been ignored, nothing stops you at the stage of mitigation to indicate to the court that those facts do exist and they may be of assistance to your client. That is important in giving the court a full picture of your case. Now, something that needs to go out to the prosecutors, the few might be on board this afternoon. It is not right for prosecution to overload charges so that we create room for plea bargains. Let us make the charging decisions in a very transparent manner and make sure that we only charge people with those offenses that really they are guilty of or there is probable cause to proceed against them on. Because some of the criticisms that you find on the process of plea bargaining world over is that prosecutors tend to overload charges so that they're able to extract a plea bargain. That we can avoid, and I think it's in good sense and fairness that all should work towards a process that is fair to all. Now, why embrace plea bargaining? You realize today we have quite a big workload in terms of backlog in our courts. We can reduce those cases so that we create time and resources for handling of more complex cases. That will be of a positive impact on the society generally, because you will have accused persons not having to queue and wait for months and years before their trials are done. Now, legal representation in the process of plea bargaining, here as advocates, I would want to challenge you. Those of you who have proper briefs that you have been allocated, please, one way of ensuring that you don't really have to stay in the courtroom for long in a process that probably is not even remunerative enough is for you to explore plea bargaining in those cases that you think you can actually have the matter resolved by way of plea bargaining. And let us not confuse the two. When you opt for plea bargaining other than alternative justice mechanisms, then it means you will be coming into the formal court process. We deal with the plea bargain. But if you go to the AJS system, then you will be trying to resolve the matter out there, and probably what you can come with to the formal court system as a defense attorney with the prosecution is a request, say, for instance, to terminate the charges that had been preferred because justice has been rendered through another mechanism. I have handled one or two cases where matters have been resolved outside the court system, and we have had to sanction the withdrawal of those prosecutions with, of course, the concurrence of all the victims. And when you look at the justice of the case, you realize that justice has been served. So the other advantage of plea bargaining is certainty of outcomes. You know for sure when you have gone into a plea bargain, there is some comfort in knowing that the range of sentences you have given is this. So in all likelihood, you may end up with one of those sentences being imposed, other than a situation where you go for a trial blindly and then the court eventually surprises you together with your client. There is leniency and predictability, avoiding the stigma that goes with public trial, and also saving costs for witnesses and the entire spectrum of society that is interested in a matter that is in court. Expedited resolution of cases is the other advantage, and for victims, restitution and compensation really are key. You avoid re-traumatizing a victim who has lost a relative, or was, lost property, even in those cases outside murder, where you have to go into plea bargains. So closure will be easy for victims of crime when you do plea bargains. And please, let's remember, this procedure is not only for homicide cases. We can replicate this in all other cases where, say, for instance, you have a complex fraud case. You could go for things like stealing, obtaining, and such like offenses where the facts would be able to support such a case. So what is your role as the lawyer in this case? As a lawyer, please evaluate your case and do a risk assessment. What is it that I stand or my client stands to lose if we were to opt for a full trial? When you weigh that carefully, then it may dawn on you that it is important to cut short the process by taking up a plea again. So thinking of charge bargaining, draw as an advocate, once you have evaluated your case, draw all the possible charges you can prefer as a prosecutor. Now you are the defense attorney, but then you're asking yourself, if I were the prosecutor confronted with these facts and evidence, what would I have come up with? Once you have that array, then you can approach the prosecutor and try to bargain for the best chance that you get out of that negotiation. Okay, so that I don't take much of your time, the plea bargaining concept in most jurisdictions has been utilized to what I would call resolve cases up to about 90%. In fact, in the US, they say it's about 98%. In Australia, it's 70%, and many other jurisdictions where people have embraced plea bargaining. So it is for us as a people and as advocates to ask ourselves, why is this not working? Why are we not implementing this portion? And to you, the Nairobi branch, the officials of it, please take up this sensitization process in all the fora that you go. Talk about plea bargaining. Let Kenyans know about it and let them come forward and embrace it. With that, I thank you for listening and I'll wait for questions. I hope I have not taken too long. Thank you, Mudani.
You're on time, Judge. Thank you very much. We'll have our second speaker, Ms. Becky Arunga. Then we will now go to the question and answers. I'm seeing some questions coming up. Please proceed, continue letting them on the chat, and we will address them after Ms. Arunga has given us her presentation. Thank you.
Good afternoon.
Good afternoon.
Please confirm whether I am audible enough.
Yes, we can hear you.
Okay. Thank you very much. I'd like to extend my gratitude to Justice Muteti for laying a very good foundation upon which this presentation on plea bargaining is laid. I also thank LSK Nairobi branch for extending an olive branch to the office of the DPP to be part of this session. Receive the regards of the DPP as we proceed with this presentation. So a number of the issues regarding plea bargain and plea agreements have been discussed by Justice Muteti. And just to avoid repeating or regurgitating what he has said, I would just like to emphasize the fact that plea bargain, as it is, it's an agreement between the prosecution and the accused person. And a question would be asked, what role then does the victim play in plea bargain? And the ODPP plea bargain guidelines 2019 guide prosecutors alongside the Criminal Procedure Code, section 137A to 137O, on the conduct and nature of plea bargains. The plea bargain, the ODPP plea bargain guidelines foresee a situation whereby in the course of undertaking plea bargain, the victim's sentiments are taken into consideration. Of course, in light of the Supreme Court decision in the Lendrix Waswa case we have come to appreciate the role that victims' counsel play in the criminal cases. Therefore, whatsoever decisions are made by the prosecution as regards the conduct of a criminal case would be, they would be required to seek, to consult with or to inform the victim's counsel on every step that is taken towards resolution of a case that has been forwarded for consideration. To that end, we see that that is the first safeguard that has been placed by the courts or by the law to ensure that plea bargain meets the end of justice, as opposed to being misused for the sake of circumventing the course of justice. The fact that there is judicial intervention before a plea bargain can be fully confirmed as an order of the court is a clear safeguard that ensures that the victim's rights or the overall justice system is not made a mockery of. Moving forward, as Justice Muteti mentioned, a party can request for plea bargain either the accused person or the victim or the prosecutor or even the investigating officer can assist or the request to the prosecution team for purposes of plea bargain. But ultimately, when the time comes for making a decision, the prosecutor or the DPP reserves the right on how this would proceed. And this is based on the fact that the Constitution has, according to the Constitution of Kenya 2010, Article 157, the DPP, the Director of Public Prosecution, has the mandate to institute criminal proceedings, to discontinue criminal proceedings, or to take over criminal proceedings in the public interest and in the interest of the wider administration of justice. So it is very crucial to appreciate that where us, a victim's counsel or a victim, would be consulted, the ultimate decision on how to proceed would vest on the DPP. Then when the decision goes to court, then the judge or the judicial officer having conduct of the matter would have an opportunity to assess whether the bargain agreement is in tandem with the spirit of justice or is acting against the interests of the public. From a prosecution point of view, a plea bargain agreement may be terminated if it is procured through fraud, through misrepresentation, or the accused person is no longer willing to fulfill the end of the bargain. When such occurs, that could be brought to the attention of the court, and the court is able to make a determination on how to proceed. And the safeguard that we find in such instances, as Justice Muteti mentioned earlier, is that the judicial officer who perhaps might have had an occasion to listen to the facts of the case under the plea agreement will not continue with the determination of the matter. It will be transferred to a different judicial officer or a different judge based on the circumstances of the case. Now that Justice Muteti has spent considerable amount of time discussing the legal framework and the foundations of plea bargain, allow me just to highlight certain practical examples that have been the subject of discussion in courts of law in our country. The Court of Appeal has had opportunity to consider appeals on issues of plea bargain. Remember, as per section 137A to 137O of the Criminal Procedure Code, one cannot appeal against the conviction in a plea agreement. What one can appeal against is on the legality of the sentence that has been meted by the court. And so there has been considerations by the courts as regards to how plea bargain has been undertaken. And as we go through the session of looking into the various cases that have been determined, we'll be able to appreciate how this plays out in a practical manner. When we begin by the High Court of Kenya in Joyce Gwendo versus Chief Magistrate Court at Nairobi Anti-Corruption Division, in this matter, there was a plea bargain on economic crimes, and the accused person had been charged with several crimes ranging from issuing a bad check to stealing to fraud. And at the end of the day, there was an agreement to have a plea, there was an intention of a plea agreement between the prosecutor and the accused person. What was intended is that the accused person was supposed to compensate the victim who the victim of the offense. And so it was required that the accused person gives or issues a check worth 500,000 Kenya shillings within certain timelines. However, the aspect of compensation was not materially, the timeline of the compensation was not incorporated in the plea agreement. Therefore, after several mentions to determine whether it was possible for the plea agreement to be confirmed finally, it was found that the accused person had somehow reneged on the promise or failed to abide by the terms of the plea agreement. As a result, the trial magistrate sentenced the accused person to imprisonment by giving a custodial sentence. Now, dissatisfied and aggrieved with that decision, the accused person appealed to the High Court, raising the concern or raising the issue that having voluntarily submitted to a plea agreement, it was expected that he would get the benefit of a lenient sentence, not even a custodial sentence. And the High Court, in determining that matter, held thus: it is my conviction that the intention and spirit of the plea agreement was to compensate the victim, which has fully been satisfied. Any procedural technicalities arising out of an oversight in stipulating the clear terms of the plea agreement with the attendant consequences is curable under Article 159(2)(d) of the Constitution. The paramount consideration is attainment of substantive justice after balancing individual interests vis-a-vis that of the state and the victim of the offense in question. Therefore, the custodial sentence was set aside. The benefit of this case is that it shows us that inasmuch as the plea bargaining agreement had not expressly stated the duration that was required to have the monies refunded, when the accused finally refunded the money, even though it was out of the agreed or expected timelines, the spirit of a plea agreement was to have the compensation of the victim. Therefore, that technicality of not having compensated within the agreeable time should not be used to counter the very essence of a plea agreement and the need to have cases determined in a timely manner. And so it goes to show that when we're looking at the plea agreements, it is important to see that the court, or rather the justice system, is concerned with balancing individual rights vis-a-vis the rights of the state and the rights of the victim of the offense in question. In that regard, a plea agreement was used to settle a case that deals with economic crimes. The Court of Appeal has also had occasion to look into the concept of legality of the plea agreement. And it plays out because most of these plea agreements have often been used in cases of homicide. If we consider the case of Lukorito versus Republic, it's a 2023 Kenya Court of Appeal case. The Court of Appeal made an important statement that plea agreements serve an important beneficial role in the criminal justice system, in that they increase the efficiency of the system by saving time and money, which would have otherwise been spent on lengthy trials. They also benefit the victim and her family because they are spared the public trial and its accompanying emotional trauma. Also, plea agreements offer more certainty to both the prosecutor and the victims of crime and the accused person. Therefore, it is a judicial policy to encourage and incentivize plea agreements in appropriate cases. In that particular case, a person who had plea bargained for an offense of murder had their sentence reduced from life imprisonment to 15 years imprisonment. Why? Because the court was considering and saying, if you want to use plea bargain as a means of reducing backlog, as a means of ensuring that victims get prompt justice, as a means of ensuring that both the and the state have a way of expediting trials, how be it then that a person who agreed or willingly volunteered to take part in a plea agreement was sentenced to life imprisonment. The Court of Appeal it is a judicial policy to incentivize plea agreements, and therefore having to sentence someone to life imprisonment went contrary to the spirit of the plea agreement, and subsequently, the sentence was reduced to 15 years imprisonment. And so there is this, there's a move by the Court of Appeal to recognize that indeed plea agreements and plea bargains are very beneficial and essential to a well-operating criminal justice system that is both efficient and correctional in nature. Something else that has also come up in the course of plea bargain is what to do when you're dealing with a plea agreement involving multiple accused persons. And I've reiterated that a plea agreement is between an accused person and a prosecutor. They are dealt with as at an individual level. One cannot plea bargain on behalf of the other. To mean that whereas accused number one might want to engage in a plea bargain, accused number 2 or 3 or 4 may not want to be part of the plea bargain. So what happens, especially considering that the facts or admission by accused number 1 might actually be incriminating on accused number 2, 3, and 4, especially if all that information is made before one judicial officer or one judge. There is a case that dealt with that in Republic versus Kebuaro and 5 others. It's a 2024 case from the High Court. In that particular case, accused number 1 had entered into a plea agreement with the prosecution on a case, and therefore, while one of the issues that the defense counsel raised at the point of adoption of the plea bargain agreement is that the agreement contained information that was adverse to the fair hearing rights of the second, third, and fourth accused person. And therefore, adopting that plea bargain in that particular court file would not be safeguarding the rights of the accused person in as much as it was going to help the state to expedite or expeditiously determine the case or finish the case against the accused person. As a result, the judge concurred with the defense counsel and determined that instead of that plea agreement being done in that particular parent file, a separate file be opened where that particular accused person would be charged, and then the plea agreement together with all the facts would be read in that particular file. As a result, it would prevent a situation whereby the court would be subjective, having looked at or had an opportunity to see or hear the evidence made by one accused against other accused persons. So it was a safeguard that the judge gave, and in making his statements, he said, I find the plea agreement as drawn cannot be allowed to be on this court record. The prosecution ought to proceed to separately charge the first accused so that such incriminating averments do not form part of the court record herein. And the reason for highlighting this particular case is that it goes to show us that in as much as we have plea bargain agreements, they do not vitiate the right to fair hearing. The rights to fair hearing are still retained regardless of whether the fact that the accused has voluntarily submitted themselves to a plea agreement. And the fact that the enjoyance of the fair hearing rights by one accused person do not bar the enjoyment of such rights by other accused person. And so the judge was very clear that such incriminating averments ought not be retained in this file. Instead, let a separate file be opened and the accused person be charged separately so that the plea agreement be considered in that particular file. And I want us to be carefully highlighting the safeguards that continually come from a practical view or version or practical engagement of plea bargains in the court system. In another similar case, we want to ask ourselves, what happens when you initiate a plea agreement, but the victim is totally opposed to it? How do we proceed? There is a similar case that the High Court dealt with, and they highlighted the various nuances that have to be balanced when dealing with the plea agreement where the victim is opposed to it. The facts of the case are the offense of murder. From the very outset, the accused sought remained. However, in the first instance, the prosecution declined the request for a plea agreement from the accused and preferred instead that the matter proceeds to a full trial. In the course of the trial, towards the close of the prosecution case, the prosecution reconsidered its stand and offered to have the case determined through plea bargaining on request of the accused person. However, at this particular point, the victim's counsel and the victim objected to it, and they were not keen to have the plea bargain continue on the basis that a similar request had been made earlier and rejected. Why was it necessary that that same request be brought out at this particular point in time when the case had greatly advanced? The sentiments of the victim's counsel, the objection were later followed by a judicial review application on the High Court, to the High Court, noticing that both the High Court handling the murder charge and the Judicial Review Court are courts of concurrent jurisdiction. It was not possible for the Judicial Review Court to make a determination on a file before a court of competent concurrent jurisdiction. So the file was transferred to the High Court Criminal Division to be dealt with by the judge who was handling the High Court criminal case. And in looking at that particular case, the judge was able to point out significantly certain issues that are very important in understanding plea bargain, role of victim, the role of the DPP, and the role of the accused person. In that particular case, one of the issues that the victim's family brought out, number one, is that the family was not consulted prior to the execution of the plea agreement in contravention to Section 137D of the Criminal Procedure Code. Secondly, that a previous proposal for plea agreement had been formally rejected. And thirdly, the proposal was belated and also made in bad faith. The court, in addressing the issue, pointed out that whereas the victim's family strongly objects to the plea agreement, they cannot direct the DPP to continue with the murder charge or to abort the plea bargain, as the DPP does not require the consent of any person or authority for the commencement of criminal proceedings and in the exercise of his powers of prosecution, and shall not be under the direction or control of any person or authority. In this particular case, the court recognized that whereas it is necessary to hear the representations from the victims or his counsel as regards the conduct of the plea bargain, the DPP reserved the right on determining how the case continues. And in this regard, there was a murder case already in question. It is the DPP who had the right to determine how this murder case continues. And when he elected that instead of proceeding with the murder charge, he proceeds to the plea bargain agreement, the fact that the victim's counsel opposed did not impair the DPP from performing his function. Now, this particular case also, the court emphasized that in any case, a plea agreement is not an automatic acquittal. The victim or the accused person would still be held accountable for his actions, only that instead of a full trial, the matter is done or disposed through a plea bargain. And that case was Republic versus Farah alias Isa. The last case that I wish to highlight has to deal with a situation where we have what we call Methuselah sentences in so far as plea bargain are concerned. In this particular case, the decision that I'm highlighting at this point is from the Court of Appeal, Misati versus Republic. It is a 2024 decision. In this particular case, the accused person had been drinking alcohol. And so when he came back home drunk, he got into a fight or a quarrel with his wife. In the course of quarreling with his wife, something happened and he ended up killing 4 of his children. And so the prosecution instituted 4 counts of murder against him. This was in the High Court of Kenya at Kisii. When the High Court of Kenya at Kisii considered the case through a plea agreement by the prosecution, the court recognized that whereas the accused person had had an altercation with his wife, killing the 4 children was an extreme measure, which warranted a deterrent sentence. For that reason, the High Court meted a sentence of 55 years imprisonment on each count. Now that would total to over 200 years imprisonment. Dissatisfied and aggrieved with that sentence of the High Court, the appellant, the accused person, appealed to the Court of Appeal. And the Court of Appeal appreciated that indeed this was a very gruesome murder, and it was done against the children. However, the 55 years imprisonment sentence was Methuselah-like, in the sense that it was harsh or it was excessive. And the question really that the Court of Appeal was asking itself is that even though the accused person merited 55 years imprisonment, was it the best way of dealing with an accused person who had submitted to a plea agreement? And the Court of Appeal had this to say: if the learned judge was persuaded that the prosecution should not have offered the plea bargain in the circumstances of the case, then he ought to have rejected it. A court cannot accept a plea agreement on a lesser charge than the one at hand and then sentence the accused person as if he had been convicted of the more serious offense. The import of this particular case law is to highlight the very place where we began, that in as much as a plea bargain agreement is between an accused person and the prosecutor, it is subject to judicial approval. Therefore, if the court is of the opinion that the circumstances of the case do not warrant a plea agreement, nothing stops the court from the very outset rejecting that plea agreement in the course of safeguarding the interests of justice. However, the mere fact that an accused person has submitted himself or herself for plea bargain is an extenuating factor that ought to be considered at the sentencing stage, so that by judicial policy, many more people are encouraged to take up plea bargain as opposed to having the matter proceed to full trial. Therefore, even when an accused person has committed an offense that in the face of it looks barbaric, the mere fact that the same has been accepted by the judicial officer ought to inform the sentencing requirements. Therefore, once a court has accepted a plea agreement on a lesser charge on one hand, it cannot now therefore proceed to charge the accused person as though he has been convicted of the more serious offense. These cases that we have highlighted go to show that plea bargain, as it were, has been accepted by the courts as a measure of reducing backlog, of ensuring prompt access to justice to a victim of an offense, and it also provides the mechanism for an accused person to enjoy the benefit of correctional services, that an offender can change, that if the criminal justice system is working, it is possible for justice to be afforded in a way that an offender can be rehabilitated and integrated back into the society. In conclusion, allow me to remark by saying the submission by an accused person to a plea bargain is an extenuating factor that the court considers in determining the appropriate sentence. This encourages the uptake of plea bargain by accused persons, hence guaranteeing prompt and speedy resolution of cases. So the prosecutors, guided by the ODPP plea bargain agreement, plea bargain guidelines, would be in a position to develop or have a plea bargain agreement that would be submitted to the court for consideration. And when we look at the plea bargain agreement, we can remember our contract law coming to play. that there has to be issues of voluntariness or willingness to be part of the plea agreement without any coercion. The victim's counsel the victim is consulted, and the matter is submitted for judicial authorization or acceptance. And once a plea agreement has been made and a conviction therefrom made, the accused person can only appeal against the legality of the sentence and not the conviction that has been meted against them. In that regard, plea bargain is a welcome relief to practitioners to ensure that all the safeguards, while all the safeguards of a fair trial are met, the accused person still gets an opportunity to have an expedited trial that respects whether any compensation or safeguards have been made. Again, just to highlight that other than sexual offenses, plea bargain is not welcome in crimes against humanity, cases of genocide, or cases of war. So those two are expressly excluded by the Act. And in these other cases, whether it be economic crimes, whether it be offenses against the person, a plea bargain agreement can be entered into. Looking at now future aspects of plea bargain, I may just need to add that because plea bargain safeguards privacy by ensuring that one is not exposed to the rigors of a public trial, it comes in handy in dealing with offenses where privacy is key. For instance, offenses that deals with cyber and related issues. Instead of having to divulge how a system was unauthorized or how a particular cyber criminal breached the digital systems of a nation or of an organization, when entering into a plea agreement with such cyber criminals would safeguard the means through which they interfered with the systems, but at the same time ensuring that they are accountable for the cyber crimes that they might have committed. Thank you very much for the session, and I welcome any questions that might require clarification. Thank you.
Thank you very much, Becky. So we'll take 2 questions and then we'll have the panelists respond to the same. I read them from the chat. The first question was from Edward, and Edward asked, this question goes to Judge. So Judge, how do we manage expectations on the part of the accused persons? Some of them seem to think that they will get away scot-free. Then the next question was asked by Redemptor, but I think Becky dealt with this when you were discussing. The question goes, in a case where there is more than one accused person, can plea bargain be done for one of the accused persons? I think Becky dealt with it, but maybe you can just expound on it. So we can have those 2 questions first, then we go to the others. Welcome, Judge.
Thank you. Debunking this myth of accused persons believing that once I plead guilty, I am going to go scot-free. One of the things you can do as an advocate is this. When you sit with your client, take him through the regime of sentencing in this country. When you talk about murder, what is the penalty there? And then if you climb down to manslaughter, what are the possible sentences that one is likely to get? So that at the end of the day, once an accused person gets to understand that if they try me for murder and perchance they convict me for murder, then I am liable to the sentence of death and probably a very long prison term. While on the other hand, if I were to accept to plead guilty to manslaughter, then I stand the chance of even getting a probation. So that when Becky talks about the stage at which a plea bargain is entered into, you should be able to tell your client, look, if we plea bargain at the earliest, then obviously we will have saved court's time and everybody's expense, and you are likely to get a lighter sentence. And that ties into a question that I've also seen on the chat by someone asking whether plea bargain equals a lenient sentence. And the answer is yes. If you plead guilty to an offense, obviously the court will give you some credit for that. And it is a credit that you are entitled to in law, because you will have really accepted one liability for the action or responsibility for the action, and then two, you have saved everybody the trouble of going through an entire trial. Now, the other question was about victims. I've seen something about victims, and this really appears to be a big concern to most of the persons who have posed questions there. And whether victims have a voice. Yes, they do have a voice. And the thing is, victims ought to be consulted. That is a requirement of the law. And where they are not consulted, nothing stops you as counsel for victims when you appear before court to raise the question that there is a plea agreement that was entered into and we were not consulted. But then you as a counsel for victims, you also have a duty to advise your victims. Let them understand what are the limits, to what extent can they influence the decision of the DPP. Submit the necessary information to the DPP, let the DPP consider it, but then remind them that the court has the last word on the whole matter, whether it will be sentencing or the nature of conviction that will be returned. Because I have seen quite a number of victims come to court believing that actually it's a case of an eye for an eye. If somebody died, then this man must also die. Tell them we don't even hang them, even if we sentence them to death, so that they start socializing themselves to the fact that at the end of the day, this man will get some prison term and they may eventually actually come out sometime during their lifetime. It is important because victims must appreciate what the law is and what are the limits they can push the courts and also the DPP too. Then how do I deal with this issue of victims where it is clear that they were not consulted? As I have said, raise it in court. From my own experience and in my court, the way I approach it is this. I will ask whether victims have been consulted. I will put that down on record. If there is no counsel for victims, but these victims have not been consulted, then I will also call for a pre-sentence report. Of course, in the pre-sentence report, I will expect that victims will have been consulted, and I will check from that report whether indeed they were consulted. But for Becky, please take the message back. If you don't consult victims, definitely these plea bargains will be trashed. I can assure you, if you look at keenly the reasoning of the Supreme Court in the Ledricks Waswa case, it may not have happened so far, but I can foresee a situation where even a plea agreement will be vitiated on account of omission to consult victims. Let them put on record what it is that they would want to say so that a court has an opportunity to also look at their concerns. I think I've answered quite a bit of the issues. Okay, separation of trials, sorry, where there are multiple persons charged. Yes, I think the proper way to go is this. If your client is jointly charged with others who are not ready to plead guilty, ask the court to order a separate trial. You don't even have to wait for the prosecutor where it is clear the prosecution is not moving at the same speed with you because you're an advocate. You can say, my client wants to take a special course. We wish to petition for a separate trial. Let the DPP separate this trial and the courts will intervene and make sure the necessary is done so that we fast track these matters. And someone has asked, when you enter into a plea bargain, must you also undertake to give evidence as a witness in the trial? No, that is not given in all cases. There are instances, of course, where the part of the bargain will be, we are going to accept a lesser offense of manslaughter on one condition, that you are going to testify in this case. That may be a demand by the prosecution, and if your client accedes to it, based on the facts again, that they really have to contend with, that may become a possibility. So there are instances, yes, where a person who has pleaded guilty will come as a prosecution witness, or there are other cases where they will plead guilty and they will not be required to be witnesses at the end of the day. Thank you.
Thank you, Judge. I think Judge also answered the question of where there are multiple accused persons and only one accused person wants the plea bargain. There's another question. Are police officers investigating these cases onboarded in the plea bargaining process? And the other question, can plea bargain be done on appeal? We can take those two first.
Okay, quickly, police officers or investigators, yes, in all plea bargains, they are to be informed. But again, as was explained by Becky, whatever position they give to the prosecutor does not bind the prosecutor, because the decision on what charge to prefer remains that of the prosecutor. But they ought to be informed and consulted, and also their views taken on board. And that ties into another question that you will see in the chat by someone asking, this issue of plea bargains in economic crimes is indeed one of those things that are going to encourage reoffending. My answer and quick answer to it is no. One of the most powerful tools of fighting economic crimes is taking away the benefit from those who are accused of economic crimes. So that if we can extract a very big number of plea bargains on all economic offenses, I can assure you these people will stop stealing, because they will realize once we catch you, you either give us like 95% of it or we send you to prison. And the risk is this. And you can confirm from the plea agreements that you will see in economic crimes, where somebody is ready to plea bargain in an economic crime, there is direct evidence that is incriminating them. But again, trials being what they are, you may opt not to enter into a plea bargain, pursue a trial. What happens when your key witness dies in the course of trial and you cannot resurrect them to come and give evidence? What happens when buildings burn and all evidence is consumed in fire? So there are very many other things that you must take into account even when you pursue plea bargains. So I've dealt with the police officers. Sorry, Donnie, I forgot the other bit of it.
Yeah, the other question was, can
Yeah.
plea bargain be done on appeal?
On appeal. Now, there is
Yeah.
a problem, because plea bargain, as it was conceived, the idea was this is going to be done at the trial stage. Because on appeal, you're already dealing with a convict. This is somebody who has already been, gone through the motions of trial. And the idea of plea bargain is to reduce the strain on courts in trials. So if you don't take up this, on appeal, it will not be of any help to you, because the court of appeal or the court dealing with your appeal will strictly rely on the evidence as it is on record and the decision that was made by the court, testing basically its legality. But a plea bargain cannot be of any help on appeal.
Thank you, Judge. So the other question that has been asked by Belinda, Judge, is it advisable to plea bargain on capital offenses, or that may be a gamble on the defense cases? Then the other question. Okay.
Yeah.
We can have
proceed.
okay. We can just deal. I think let's just maybe we can do
Okay.
one.
Okay. On capital offenses, yes, it is advisable, and I would encourage it, because when you look at the bundle that is given to you in a capital offense, you are able to tell whether there was actually premeditation or not. And once you are satisfied that there was no premeditation, then that is a safe case for you to go for a plea bargain. If there is premeditation, and for some reason the prosecution is willing to cede ground and also agree to a plea bargain, then the better for your client. So it is for you to do that assessment, as I said, as an advocate. What is the best chance for my client? Of course, considering that if you hoped for a full trial, then you expose your client to the most grave of punishments that is available under the law.
Thank you. This other question, I think it will get a perspective from your end as well as from Becky's end. The person Katambi is asking, what are
Yes.
your pet peeves / irritations as a judge / prosecutors about accused persons and all defense counsel when it comes to the plea bargaining process?
I'm not sure I've gotten the question. What are the what?
What are your pet peeves, all irritations as a judge, all as a prosecutor
Yes.
about the accused person and defense counsel when it comes to the plea bargaining process. I think what are your don'ts?
The thing that I really don't like is this.
Yes.
When somebody decides to make a plea offer, please, there must be seriousness that attends to that kind of an arrangement. We have seen situations where somebody makes a plea offer. Somewhere along the way, when the facts have been read, they admit the facts. You call for a pre-sentence report. When you return, they have already changed their minds and they want to take you back to the, to the whole process of a trial. Which means then eventually, because as a judge, I've already taken that or those facts on the record, I will have to cede hearing the matter and take it to a different judge. That has a very serious impact on what we intend to achieve by embracing plea bargain. If you don't intend to plea bargain, please stay away from it. Let's do the trial. At the end of the day, we will judge you based on the evidence that we receive and the law. So that for counsel, before you make that offer and you announce it to the court that you have reached a bargain, make your client understand the dangers. And let me say this. It will be a position where Judge A has disqualified themselves because they have rejected a plea offer from you. It has gone to another judge. That other judge, remember, you are using the same file. They will also have an opportunity to go through the record. Now, never mind, the judge may be as fair as anyone can be. But remember, when you have placed on record something that you want to walk away from at some stage, you are already prejudicing your client's case. So let's be clear with our clients. If we are going for plea bargain, we have analyzed the situation, looked at the entire evidence, and agreed this is the only way we can get a good deal out of the whole matter, so that you don't end up in situations where you have to keep going back and forth. And then you reject at first. After you have had 3 other witnesses, you realize, oh, I'm cornered, you come back. That is wasting time, and the court may not look at you very kindly. Becky, you could add to that?
Yes, please,
Thank
Becky,
you.
give us your perspective.
Thank you very much. So from a prosecution's point of view, the fact that a plea agreement or the intention to enter into a plea agreement is being used to twist the performance of another action. By way of example, because the victims of offenses are usually consulted in the course of preparing the plea agreement, you might find there are some other things going on behind the scenes that are not known to the prosecutor. And so by the time they are coming for plea agreement, it is unofficial, or there is secrecy between both the accused and the victim, and none wants to talk about it much. But when they are unable to agree amongst themselves, they come back and say, we want to proceed, just similar to what the judge has mentioned. So that there is some dangling of the carrot that happens behind the scene that is totally not mentioned to the prosecution counsel. So it appears as though you are entering into a plea bargain blindsided, because there's some crucial information that might affect the outcome later that is hidden away from you but known to the advocate. And this I would just require us to still adhere to candor, to be advocates who can be trusted, because you as an advocate are the brand that you are presenting. And my interaction with the counsel, if it appears as though the counsel is not objective, or is withholding some information, or is not operating candidly, it is very possible for me to form an opinion against them, because I'm human. But it is because the legal profession is tightly knit. It's just an appeal that we observe the rules of candor and bring to the table that which would ensure that we develop and come up with a fair plea agreement that would ultimately dispose the case in a manner that safeguards the interests of justice. No need for us to enter into a plea agreement blindsidedly, then one of the parties comes to complain later, perceiving that one has been bought or not. If everything were placed at the table of agreement or negotiation, it becomes very easy for the prosecution to determine what to do with that information towards ensuring access to justice and safeguarding the interests of justice. Thank you.
Thank you, Becky. The other question from Sharon is, what is the difference between a conviction after a plea bargain versus a conviction after a full trial? Maybe Judge, you can take that.
Once you plead guilty as to the offense of whatever the offense that you have agreed on with the prosecutor in plea bargain, obviously the conviction will come immediately after your admission of the facts. That is almost what I would call a summary trial will happen, because we will have had the facts, you have admitted them, and then we proceed and convict you. Whereas if you are going to convictions after full trial, it means every other witness has come and given their side of the story, and the court eventually finds that you are guilty. Well, at the end of a full trial, the risk is this: if you go for full trial with a murder charge, you may end up with a conviction for murder, or you may end up with a conviction for manslaughter. So that it is upon you to weigh, or based on the evidence that you have, is manslaughter a guaranteed result? If it is a guaranteed result, why would you wait to go through a trial only to end up with the same situation? And then probably at this point, let me address some other concern that has been raised, where someone is saying, what is the point of doing a plea bargain in manslaughter in a matter where the accused person ends up getting 20 years when we have cases where persons charged with murder have been sentenced to as low as 10 years imprisonment? Now, that takes you back to what Becky said. The only thing that you are precluded from appealing against in a plea agreement arrangement is the conviction. That is what the law says you cannot appeal against. So if you are unhappy with the sentence, you can move to the higher court and try your luck. You know, again, sentencing is discretionary, and looking at the facts of a case, you may actually end up with cases where even murder, somebody is given a discharge under Section 35, whereas in manslaughter, they will take 10 years, or vice versa. So it's not cut and paste that because there is a murder case where somebody was given 10, then all manslaughter cases should come below that. You will also find there is a murder case where somebody was given life imprisonment, and then there is another murder case where they were given 10 or 2 years. So it's all over there. So if you are not happy with a particular sentence, the position is just appeal against the sentence and see what the Court of Appeal will say. And hopefully, then that does not get enhanced.
Thank you, Judge. There is another question by Duva.
Yes.
He's asking that you've talked about the alternative justice system during your presentation. If parties involved, let's say for a capital offense like murder, reach an amicable conclusion to have the matter settled through that mechanism, what procedure should the advocate take to have the case against the accused dropped or terminated?
Very good question. I think once you go for AJS, probably the community from where these two people come from accepts that kind of settlement. You conclude that arrangement, but please document these things. If you go to a masla sitting and people sit there, they agree on certain things, you document, and your client honors each and every part of the bargain or whatever they have agreed on, and the matter is fully settled. Document these things. The next step, write to the DPP. Tell the DPP, yes, my person so and so, accused of this, has approached the other family and they settled the matter. Consider dropping the charges. The DPP will exercise the options available to him under Section 82, whether they will enter annul or they can withdraw if it's a matter of a different nature below the lower in the lower court under 87A. If the DPP does not drop the charges and you have already gone through AJS, never mind, don't lose hope. When you come to the High Court, Becky is there insisting on proceeding with murder or whatever charge it is they are proceeding with. Indicate to the court that we had gone to the AJS process. That will be taken note of. And I can assure you there is no judge who, when it comes from the victims and the accused persons, that a resolution had already been reached, will be averse to reception of that information. It could come in the form of your defense. When you come to your defense, you could apologize for everything that you did as an accused person and end up saying reparations have been done. We have settled this matter through our traditional mechanisms. Then the judge will also get an opportunity to tell the DPP something about Article 159 2D. Thank you.
Thank you, Judge. There's another question by Redemptor. After entering into a plea bargain, does the accused have to agree to testify against co-accused, or is it voluntary?
That I had mentioned earlier, I said it is not in all plea bargain cases where an accused person will be required to testify once they enter into a plea agreement and plead guilty. But there are instances, say for example, I'll give you one live case. Those of you remember the Kiambu case of that principal where the lady was accused of having murdered the husband, and then eventually one of the accused persons pleaded guilty. He was utilized later as a prosecution witness against the rest. There could be such cases where a member of a gang that commits an offense agrees, please, I'm not ready to face trial, give me manslaughter, I can run with my 10, 15 or 20 years, whatever it is, and in exchange thereof, I will be ready to testify against these guys who are ready to face the charge of murder. That will be entirely an agreement between the prosecution and the defense.
Thank you, Judge. The other question is, can pleading guilty during pre-taking be considered for lenient sentence? Talk about plea bargain or diversion and defilement matters.
Yes, if you plead guilty at the plea stage, or you immediately after plea stage offer to plead guilty to a lesser offense, that would definitely impact on your sentence positively. Why is that important? Because you are coming at a very early stage in the proceedings and saying, I admit my guilt, and therefore this court should temper justice with mercy. Definitely the court will give that consideration. The other portion of the question was?
Can a judge, the other part of the question, or talk about plea bargain or diversion and defilement matters.
Defilement cases.
Yes.
Now, I know this is a very hot area on diversion, for example, in sexual offenses. And this, I think, it's a duty we all have as advocates and everybody in the legal sector. Let us start asking ourselves a very hard question. Sexual Offences Act criminalizes all those acts under Section 8. But then the offenders are all below 18. What is the best course for the DPP to take? Is it diversion or to charge the boy and leave out the girl, or charge both? Or what exactly do we do? Those are hard questions. I know for a fact diversion has been embraced so that we take care of some of these situations that could be remedied otherwise than by way of punishment. So that diversion aspect has some limitations. And I think it's for you as advocates, if you want diversion, just write straight to the prosecutor, propose why diversion and what is the best form of resolution and that you think. With sexual offenses, I think that mostly should go when you are considering issues of children and how do you reform them, or how best can you rehabilitate these kids. Plea bargaining for sexual offenses is an absolute no. The law does not allow it. So again, that is why diversion only becomes available at that very early stage. Becky could also chip into that.
Thank you very much, Judge. As you have mentioned that plea bargain is not available for sexual offenses. Diversion is available where the offenders are below the age of 18 and they are both children, towards the move of ensuring that children are not put in institutions, and to have every decision made touching a child being made in the best interest of the child. However, the ODPP has a diversion policy and guideline that would require a whole separate presentation from plea bargain. So that might require us to pick it up at another future stage to comprehensively guide through what is required for plea bargain or not. I might have seen someone on the questions asking of what benefit is plea bargain to everyone, because it appears as though plea bargain only benefits maybe the state or is it the accused person. I just want to point us to the fact that plea bargain is very beneficial, not just to the state or the public or the accused, but to the accused person, the victim of the offense, the judiciary, the prosecutors. Just to highlight from at the victim, the plea bargain assists. There is knowledge that accused person will not go unpunished for a crime. Remember, the victim's counsel is involved, or the victim is involved during the plea bargaining process, and they are consulted. They are able to walk the journey and know what are the parameters of this plea agreement. So they are aware that they get to see that the accused person is not unpunished. There is always the immediate sense of closure. We realize the fact that criminal trials can take a very long time in our country based on systemic issues and the exigencies of work. However, with plea bargain, there's an immediate sense of closure. As a victim, you're able to know that so-and-so did this, and as a result, this is the outcome. You are able to either, if it's an offense that compensation is welcome, there's compensation. If it's a matter where the person gets a custodial sentence, you are able to see it in your lifetime that justice has been served. Then it allows the victim to make representations to the prosecutor regarding the plea agreement contents. To the public, there is a conservation of public resources, judicial time. If it is an economic crime, there can be recovery of money to the public, therefore reducing or eliminating the taxpayers' money that is incurred through public trials. And then it provides a final and definitive resolution on the matter. Those who are convicted get an expedited criminal trial. They can see what next to do with their life. And ultimately is, if you're able to have cases determined expeditedly, there is confidence in the criminal justice system. To the judiciary, the benefit that Justice Muteti highlighted earlier, there is quick and efficient disposal of cases. There is a reduction in backlog, and it shortens the time for judicial case management and oversight. The accused person avoids time-intensive and potentially costly trial. It removes anxiety, and it might result in a lower sentence, because plea bargain is where you plea bargain from a more serious offense to a lesser offense. If it is a murder, it is from murder to manslaughter. If it is robbery with violence, from robbery with violence to simple robbery. If it's an economic crime, there is a way in which you can plead from a more serious crime to a less serious crime. And for us as prosecutors, plea bargain grants us flexibility in handling criminal caseloads and enables us to reallocate the scarce resources to more trial-worthy cases. It offers a quick, efficient method of resolving cases and ensures a conviction is received and justice served. And what I also mentioned is that there's privacy when you have plea bargain, because the entire issues on how the matter, on how the criminal offense was undertaken, or the testimony of PW1 to up to end, is not captured. What is captured is the facts of the case and the analysis as per the legal analysis on how the case ought to be done. So for highly sensitive crimes that are not sexual offenses in nature, highly sensitive crimes, it would be very useful to have this plea bargain as a mechanism for ensuring expeditious justice while maintaining accountability. Thank you.
Maybe allow me, Mudoni, to add one thing for the victims, because I know that's where the concern is mainly. Please remember, when you are advising victims, to also caution them that a trial has no guarantees in it. It could collapse for very many reasons, so that they should also know there is a possibility of acquittal. I think that is where most victims do not seem to look at that direction, the direction of an acquittal. You could insist on a trial where somebody is ready to take responsibility only for them to be acquitted. That is an eventuality that no one wants to face when they knew they had a case. And take time to tell them the reasons, the very many reasons that may actually lead to an acquittal, including a violation of the human rights of an accused person in the course of a trial. So many things that advocates really need to take their clients through, because this issue of plea bargain, it is time as a country we embraced it and agreed it is the best way to resolve most of these cases.
Thank you, Judge. I have another question from Cynthia. Can a judge or judicial officer vary the terms of a pre-agreement?
The answer is no. You can only exercise your power as a judicial officer by either rejecting the plea agreement or wait until the opportunity for sentencing, and that is when you exercise your discretion. But you cannot, it is not the business of the court to alter what parties have agreed on, because that is a contract, basically.
Yes. Thank you, Judge. Becky, this question is, I think for you. Upon rejection of a pre-agreement by a judicial officer, does transferring the case to a different judicial officer really cure the apparent prejudice against the accused, considering the agreement remains on record for the new judge to perceive?
Thank you very much. I think Justice Muteti alluded to this earlier when he was commenting about the things that acts him as a judicial officer in conduct of defense counsel and plea bargain. And he mentioned that a judicial officer has taken an oath of fairness. And it's important that once a plea bargain is entered into, it is important for the counsel to honor it to the end. However, if a plea bargain is not honored, or rather it's been rejected, transferring it to a different judge is very important, in the sense that that judicial officer would be making a determination on the case, not based on what had been written in the plea agreement, but based on the fresh evidence that the witnesses lined up by the prosecution will have presented. So even though he might have had reason to appreciate or know what is in the content of the plea agreement, when it comes to the judicial decisions, I think this judge is better placed to answer this bit, but judicial determination are based on evidence presented in court. So the apparent prejudice that might exist by virtue of him being human does not supersede the judicial oath that requires that evidence be the sole basis for determining of cases or disputes between parties. So we need to give our judicial officers and judges the benefit of doubt that they are going to abide by the judicial oath and make decisions solely based on the evidence before court, and not prior representations via a plea agreement that has since been rejected or terminated. Thank you.
Just a comment on that. I think the independence of a judicial officer or a judge, really, that one you can bank on. But the caution that I gave was this. Don't go into plea bargains if you don't really intend to end that way with your matter. But something for you, Becky, and the Law Society. I think it's time we relooked at the regulations. Once a plea bargain has collapsed, I think we need to reform the law so that we expunge these things from the record completely, because that will eliminate now the fear that is apparent that one may, in the course of writing judgment after a lengthy trial, come across these documents, and those human frailties are there. But the independence of the mind of the judge to safeguard it, why don't we then take the position that as a country, and our rules or regulations that we have, once a plea bargain has collapsed, then that file is closed and entirely a new file opened, or we expunge those documents completely from the record, so that nobody ever has an opportunity to look at such incriminating material. Because basically, if somebody had signed to an agreement where they admitted an offense, that is a risk by itself.
Thank you, Judge. There's a question by Charity. Can an accused ask to enter into a pre-agreement during defense hearing? This is after the prosecution case and the accused has been found to have a case to answer. Can you get your perspective, Judge?
Sorry, repeat the question.
Can an accused person ask to
Yes.
enter into a pre-agreement during defense hearing? This is after the prosecution case and the accused has been found to have a case to answer.
Well, yes, I have seen situations where accused persons are offering to plead guilty to the lesser offense after you have already surpassed the stage of no case to answer. Obviously, the question that you ask is this: the evidence has already been had. You are at the stage of defense. If the prosecution is not really minded to accept your plea, then you will have very little chance to wiggle yourself out. Now, the most important thing should be this: at that point in time, when you're offering the plea bargain, remember this: the judge has already had the evidence. So the risk of rejection of that plea offer or plea agreement, even after you concluded with the prosecutor, is even heightened. So it is not strategically correct for one to wait until the court has tested the evidence to the point of no case to answer, and then you offer to plead, because now you realize you are cornered. So it is about you being strategic and gauging at what stage do I offer to plead guilty to the lesser offense, and will that be of benefit to me? Because chances are that if you do it after the prosecution has closed his case, rarely will that plea agreement even be acceded to.
Thank you, Judge. There's a question by Caroline. What happens in a situation where both the victim and the accused are from the same family, and whereas the accused wants to enter into a pre-bargaining agreement, the victim's family are not interested in prosecuting the suit, and they're saying they have forgiven the accused? What should happen in such kind of a scenario?
Becky, tell us, what do you do as a prosecutor? You have lost your witness and the accused is there.
That's dependent on the case for which plea bargaining is sought. Because we note, as it were, that the proper complainant in all criminal cases is the prosecution, the DPP. And the DPP institutes prosecution in the public interest and in the interest of the administration of justice. Now, depending on the case at hand, we would want to ask ourselves, what is the ramifications of letting this person go? Because there are mechanisms for withdrawing. When you're looking at a plea agreement, the person would plead. I have seen cases where an accused person killed the father under circumstances that are considered accidental, and they were charged with the offense of murder. After a plea bargain, it was reduced to manslaughter. The family went and forgave him, and they agreed that they have nothing against him. So that information is useful in the plea agreement because it informs the decision of the court as to what to do next. Remember, in as much as the family has forgiven, there is a criminal offense that has been committed. So instead of having, in that particular case, the judge sentenced the accused person to 5 years imprisonment because he had spent 3 years imprisonment in custody while on remand. That was factored in the sentencing, so that ultimately he ended up almost walking away, having received the benefit of remission. This is because there's a delicate balance between protecting individual interests and protecting the society at large. And at that particular regard, the mere fact that the family has forgiven a person does not take away the criminal record. So if it is a situation whereby a plea bargain can be entered, in those circumstances, the judicial officer properly guided is able to know what course of action to pursue if it is a plea bargain. In the context of a criminal trial, there will be if there is no other witness to sustain this particular charge, then such a charge will not proceed. But one of the safeguards we need to know is that one of the other things that happen in a criminal trial is that it leaves a criminal record on a person. The criminal record remains whether you have plea bargained or pleaded guilty, as long as the offense in question attracts a penalty of more than 6 months. And for purposes of safeguarding the public interest, each decision is, each case would be determined on its own merit. If it is one whereby the plea bargain would require a reduction of a charge, maybe to manslaughter, the judicial officer, properly appreciating the facts, would be able to tell that this one is suitable for such and such a case. There are cases where the offense has been significantly reduced, the criminal record remains. There are cases where the offenses have been, the proper sentence, deterrent in nature as well, has been retained. So the decision or the determination will be made on its own merits, properly appreciating the facts of the case, as it were. Thank you.
Maybe it's just to add on to what Becky has said. If you are talking about a family murder, I think the advocates, you have a bigger duty here, because you have the victim on the one side and then the accused person, and these are all members of the same family. That is why I talked about AJS, and I think AJS would play a bigger role in cases such as those, so that when you approach the DPP, who is now the authority that brings these cases to court, they can make a determination at that stage, even before charge, whether really this is a matter we need to carry on and take it to court. Because I would also hate as a judge to sit, and Becky is before me every morning telling me they're asking for adjournments to look for witnesses, and these witnesses will never appear. I'll give you a practical example. I once did a matter when I was a prosecutor in Meru, many years back. This gentleman had been sitting in custody for 7 years. And one morning, he just called me to the dock and told me, "Prosecutor, can I help you? Your witnesses will never come. So make a decision. Either you are continuing with this case or you are going to drop it." And indeed, when I got hold of the DCIO told me, "We can't even locate those people." I think that guy was just being honest. And, these are the kind of situations that you need to pass to the prosecutor. Tell the prosecutor this is the case. This family is not ready to push on with this trial. Much as a society would want everybody prosecuted, we must accept there are those situations where then prosecutions will not be feasible, and you will end up with a dead file on arrival. Thank you.
Thank you, Judge. Our final question. Once a plea agreement has been rejected by one court, can you file another one before the court to which the matter has been transferred?
Now, that is a tricky issue because, number one, when you go before the other judge, that is the judge who is supposed to try your case. And you are going to appear before that judge with a record from the previous court. Now, two things are likely to happen. The judge who disqualify themselves from trying the matter may have made comments that are already prejudicial to your client or any attempt for a plea bargain thereafter. Secondly, the reasons for rejection, if the court will have said, for instance, that having heard the facts or whatever it is, I do not think these are cases that merits a plea bargain. The question of jurisdiction arises. Don't you have a decision of the High Court on the question of reduction of the charge? Because that is an order by a judge. Now you are going before a judge of concurrent jurisdiction to say, we want you to relook at the matter. What are you telling this judge? So those are jurisprudential questions that you will need to confront before that trial judge.
We have comments. We appreciate the good comments from Cynthia, Davin, Otto, and Amos. Is there any other question? Okay. This juncture, I wish to appreciate our speakers. There is one more question that has just come in from Emmanuel. If an accused person has entered and approved the court, will it affect the accused person's criminal record?
If who has approached the court?
If an accused person has entered, I think maybe they meant to say if an accused person has entered a plea bargain and the same has been approved by the court, will it affect the accused person's criminal record?
Definitely, if you have signed a plea agreement and it is accepted by the court, it forms part of the record, and that will go once conviction results. Then that becomes part of your record.
I think the other question we had been answered on the aspect of appealing after the judgment has been given. You said you cannot appeal on the conviction, but on the sentence.
Yes, on sentence, that is it.
Yes. So I want to take this opportunity to appreciate our speakers. Thank you very much, Judge. Thank you very much, Becky, for taking time to come and have this discussion with us. This is a very rich area of the law, and also just giving us the practical examples. It's going to go a long way to us, the practitioners, and also the prosecutors in the house. I wish to thank our chair in absentia for ensuring that we had the speakers today, as well as the secretariat. Thank you very much. Thank you, members, for ensuring that you attended today's webinar. Without you, we wouldn't have had it. May God bless you. And at this point, we wish to have to close the webinar today, and we will see if we can have a part B of the same.
Thank you, Muthoni, and to all the attendees. I think this was a very good opportunity for us to interact, and I hope in the future you are going to organize many more webinars so that we have discussions around some of these emerging issues and areas of practice, which I think at the end of the day will be of great benefit to our society and assist the courts deal with the menace of backlog in our courts. Thank you so much for listening to me.
Thank you very much. Thank you very much for the session that we have had. I know we have not exhausted everything you would have wished to say, but time that which we have discussed will allow us to maybe discuss and study further and engage on the issues of interest. Thank you very much, and do have a good evening.
Yes, thank you very much, members. Have a good evening.